Okay, this is going to be a really interesting video. First of all, we're going to talk about Judge Hutchison. Check this out. This was his little motion after we asked him to recuse himself. I'm holding it up for everyone to go see, and this is what it says. The Honorable John A. Hutchison, Judge of the 10th Circuit Court, has advised the Chief Justice of the Supreme Court of Appeals of a motion filed for his disqualification from presiding over the above-styled case. Judge Hutchison has further advised the Chief that he does not wish to be disqualified from presiding over said case. Chief Justice Brent D. Benjamin is unavailable to consider the motion for disqualification upon review of said motion in accordance with Trial Court Rule 17.01C. The acting Chief Justice has determined that the evidence set in support of the disqualification motion is insufficient to warrant such disqualification. Really? So let's talk about this evidence. I want to bring this up because I think acting Chief Justice Benjamin here just found himself in a lawsuit. Check this out. This here is Pat Lamb's motion to put Judge Hutchison in charge. Said motion filed several months ago. There was no warning of this, no nothing of this. How I found out about this was, in fact, that none other than my internet stalker, Phil Elmore, started blasting all over Twitter that I had a bench trial in front of Hutchison. So I called my attorney. We called the circuit court, and apparently there was a clerical error which made it a bench trial, but it was indeed set before Hutchison as pushed by Pat Lamb. That's cute in and of itself. It gets better. Right here we have the verdict order from the original case dealing with Ashley Redden back in 2008, which they don't have the transcript for anymore because apparently Hutchison forgot to record anything. Amazing how that worked because, Massey forgot to record the preliminary hearing on this child porn stuff too. Strange how that is. Oh, but check this out. This is the most important part. You come to this, that one count of contributing to delinquency of a minor was removed. And then who was it in front of? Oh, right! Judge Hutchison, who might very well have to be called in as a witness to the fact that Ashley said that she was coerced by Trooper Duckworth, her mother, and the prosecutor, which I don't expect him to tell the truth, but hey, whatever. That seems really suspect. You want to make it even more suspect? Well, let's see here. No, that's not it. Yeah, let's get into a little bit more suspect here. Here we have the 8-page statement written by me at the time of my arrest. You can see, very importantly, where it's been signed and notarized. I actually typed up, actually had 3 of these printed out, signed and notarized each individually, gave one to Steve Massey as I wanted it entered on record, gave one directly to Trooper Eford, and neither one of those remember their copies, nor to put them on record. Strange how that is, but regardless, it needs to be mentioned that we're talking about a pattern of harassment. And I'm mentioning various officers. And right here we have none other than Judge Hutchison. That's right. Before he was even involved in this case, I named him. I even named Massey, even though they told me that Massey wasn't going to be involved. Oh, and here's the stuff I mentioned about fraudulent legal process, and, fraudulent filings, and all these nice little codes that they were in violation of. So, by me making a very articulate, very technical argument like that, extremely dry, what essentially ended up happening was we went to court. Now, in court, they came up with none other than this complete fabrication of bullshit talking about the second search warrant. Now, I'm going to show you something here. This is a receipt. I had to go get this the 8th of July this month. We've been waiting on the prosecutor to hand it over, but they don't want to. Here's the arrest warrant. Okay, there's a really interesting thing here in which it says, depicts a parent minors engaged in sexual explicit conduct. Apparent minors. Not necessarily if they are minors, but they appear to be minors. So if any of you are familiar with the court case involving Daisy Fuentes, the porn star also known as Little Lupe, she actually at a certain point had to go to court for a guy who had some of her pornography on his computer and was charged with child pornography. I'm not saying she's on my laptop, but what I'm saying is that there's actually a legal case of the police jumping into this and not actually doing any research. And they're using the words apparent in the warrant. It's very odd that they appear to be minors, but no one's done any investigation to find out if they are or what it is. Now, it gets really interesting when we get into this because here you see the search warrant listed for October 28th. Okay? Now, in court at the preliminary hearing, the officer in question said it was October 26th, and that's what I've been going off of because he hasn't given me that paper. He denies it even exists. In fact, this is a rebuttal to the argument on June the 11th, which was my birthday. And the date signed on this is the 18th, before the deadline of the 10-day thing, but apparently Judge Kirkpatrick is giving the prosecutor time to read it all over and make sure everything's squared away, and apparently they're not. But what we're looking at here is a very interesting case because first thing we say, we want the statements from the defendant. Everything, court transcripts, all of it. And this is the response we have. None other than statements the defendant have made on the internet or any statement made in letters to the state bar. So you have letters where I've accused you and Hutchison of being corrupt and involved in criminal activity, and yet you still want to put him over top the case. That's not a conflict of interest. That's not the appearance of criminality. I mean, something is wrong here. See, you guys can see it. So here's what I'm going to say. I actually have a statement. I'm gonna make this momentarily. Now this gets really interesting because when we come down to this is the statement, the two-page statement I wrote from the forensics lab, and I got on here mentioning how my uncle claims to be friends with certain state police officers, Deputy Jason Redden. I've pointed out that according to, let's see, it's a U.S. Supreme Court case, Brandenburg versus Ohio. This is a 1969 case. It says, directed to inciting or producing imminent lawless action and likely to incite or produce such action. This is talking about the threat of a clear and present danger. I did have terrorist material on there, but I was using it for my research, and I even mentioned it, down here, talking about that whole issue with prison-based martial arts and everything else that I was doing research into at the time. And you can see right up here where I mentioned my uncle's cop buddies. So this plays out into a very interesting thing. I even mentioned how he was charged with molesting his son, and here's the thing about it. The whole purpose of creating a second search warrant is to try and get away from that fruit of the forbidden tree doctrine. The problem you come into is this. The computers were taken based off of a knowing false testimony given to my uncle. My uncle, under oath, in an interrogatory for the court case, what was it? Oh, yes, Ronald Collins versus Rent WV, where I sued my old landlord. He involved himself in the case trying to derail it and harass me, and what he ended up doing was this. He gave me all the information I needed. He went in and made a statement under oath that he was approached by the police. The search warrant says the police approached him. Now, if my uncle's saying that the police approached him, and the police are saying, no, he approached us, and there's all this stuff in here about, you might be lying, we come to this issue of the fruit of the forbidden tree doctrine. That actually finding criminal material on my computer doesn't really mean anything because you wouldn't have been aware of it had you not been brought into it from false testimony to begin with. Then it gets really interesting in the fact that this is the other little key thing here. allow me to show you this. The date for said arrest warrant is February 25th. The date on said statement of facts: on or about February 25th, 2011, Raleigh County, in violation of West Virginia Code, cite specific section, I further state the complaint is based on the following facts. The 2/25/2011, I guess he means on, the undersigned officer executed a search warrant on address in reference to ongoing investigation against the defendant for terroristic threats. As a result of the search, the undersigned officer recovered 2 laptops owned by the defendant. The undersigned officer submitted these laptops to West Virginia Police Digital Forensics Laboratory for evidence related to terroristic threats made by the defendant. During the forensic examination, the computers... This is really interesting because, now, here's the problem. You say you give it to the forensic side, but according to my uncle, who is your witness in getting the search warrant, the pedophile, the police were lying, or he was lying, either way. Then it gets into another interesting little scenario of how he's connected to everyone and how they're all nice little buddies. How my uncle runs around saying Kristen Keller's our cousin, and she covers up for him and everything, which might be why I got away with molesting his son. Here's the really interesting part about it. They say it was February 25th. February 25th, I have a perfect alibi. I was in Southern Regional Jail for 3 days, including the 25th. So you come and take evidence out of my home, it's just, really? Imagine that. Then furthermore, it gets even more interesting that I already accused you guys of being corrupt. See, I didn't really have a whole lot of evidence to work with, but you've given me more than enough. You've put the evidence out here. And here's the thing about it. While I'm going to, essentially at some point, mail all this out with the follow-up Judicial Ethics Committee complaint, and it's all going to get looked at, ran through, and everything else. The question you need to ask yourself right now is exactly at what point, exactly where do you stand on this whole issue? Now, allow me to explain. You see, you're involving the very same people I accuse of being corrupt. You're creating a conflict of interest because I'm telling them they're corrupt. The first time Hutchinson tries to strike down evidence for these recordings on these police, it's going to show corruption. It's going to show he's biased. It's going to give me a reason to basically and essentially say, no, hold up, I want to appeal this. Let's take this to the Circuit Court of Appeals. Let's go to an appellate court just for you suppressing one little tiny piece of evidence. And we're going to drag this out for a long time, which is what you guys want. What you don't want is this. The reality. What you don't want is some of those dirty little secrets I've been really cordial about trying to keep quiet. Stuff like who in the courthouse is letting her daughter run away with her stepdad for a week ahead of time in Myrtle Beach, all by themselves to share a room. As to, who all's got issues with drugs and has been involved in a lot of criminal activity on the side. Yeah, you don't want that stuff out. It's going to be... Hell, there's going to be people that ain't even involved that's going to have their fucking skeletons falling out the closet. I don't care. See, here's the deal. I put up in another video that I was going to use the possibility of a threat of violence the most I can get out of it. That's cool. Let me point something out to you about that. Let me tell you what I get out of it. I can get up here and say, hey, I have a legal right to kill a cop. If you push me, I will do it. Nothing happens. Nothing has happened. I've said this shit. It's been almost a year and not a goddamn thing has happened. Which means either one of 3 possibilities. Either 1, I'm right. Either 2, you're scared of me. Or 3, all of the above. See, by doing nothing, by not arresting me, by giving me time to go out and commit whatever violent act you think I'm going to, so you can get up here and say, hey, there's the bad guy. See, we know he's crazy because he went and did this. We know he's, something's wrong with him because he went and did that. All you do is you prove that you have nothing. That you're trying to force me, harass me into having some kind of crazy episode where someone's going to get hurt. And of course, you think it's cool because we have helicopters with like thermal sensory shit. We have dogs. We have all this high-speed military training and APCs and all this bullshit. You think you're a fucking army, but you're not. See, if you was an army, you would be playing Op 4. You would know that there is a limitation to those thermal sensors. You would know that you can easily lose a dog. You would know what button hooking a trail means. You would know what toe poppers and Fuji stake traps are. You're not soldiers. You think you are, but you're not. That being said, I have no intention of committing a violent act. Hell, at this point, you can come and try to kill me, and I can honestly tell you that looking at all the situation, the rationalization, and the facts, these large, thick collection of evidence, things I've said, and yet you are going directly into proving me right, comes down to this. Even if you tried to kill me, I won't even retaliate. Now, I might mortally wound you, severely injure you, fuck you up, something like that. But insofar as defending myself, I have no intention of killing you. The only thing you've done is made it so much easier for me to prove that you're wrong, that you are involved in criminal activity, that you are trying to harass me, that you are trying to abuse your little cloak of authority simply by your own impotence, by your lack of doing anything. If someone can get up here and say, yeah, you can kill a cop, but yet no one does anything, why is that? I mean, why? If I'm a terroristic, pedophile, child pornographer who's threatened to kill cops, why aren't I in jail? Why aren't you coming to arrest me? Why is it I can be uptown and go to my court hearings and everything else, and yet nothing happens? The reason is because the only way you're going to come out of this smelling like roses is if I do something completely fucking stupid. That being said, I tend to get a little stupid at times. It's one of my many endearing qualities. See, at this point, all I'm saying is just keep digging a hole. And the fun part, the part I love more than anything else concerning this, is this pathetic little statement. Let me find it for you all. The lack of evidence, the fact that I even mentioned Hutchison and Massey, and these are the very people you're running to. Really? I say that they're corrupt, I accuse them of corruption and criminality, and you run to put them... See, Mr. Lamp, you don't understand. What you're doing is showing me a malicious intent to create a malicious intent to prosecute me, malicious prosecution. And I love this right here from Chief Justice Brent D. Benjamin, which came exactly 3 days after Hutchison filed whatever, in which case... it said is unavailable to consider the motion for disqualification. Upon said review of motion and in accordance with trial court rules. So here's my point. Who actually said this? Well, it wasn't Chief Justice Brent D. Benjamin. It was actually Robin Jean Davis, acting Chief Justice. Now, that being said, since we have the Davises involved, well, hey, I got some dirty laundry around here somewhere. That's right. We're going to see exactly how fast and how far shit can come down, how quickly your little house of cards can come down. Do you really think that I would follow those motions? I would do stupid shit to get you to react to it, just to have more evidence, and I wouldn't keep doing that throughout this entire trial? Look, you've tried to make me into a monster. Okay, you've created a profile for me on paper in your little system that everyone believes. The problem you have with that is that it's a profile you created, and not one for who I am, not really is what is up here, or right here. You're playing to, well, your own self-fulfilling prophecy, your own little myth. That's it. At the end of the day, I am nothing like you think I am.